Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Happy third week of March! Politico reports this week that, quote, the Trump administration is slashing the State Department's annual human rights report, cutting sections about the rights of women, the disabled, the LGBTQ plus community, and more, end quote. Indeed, quote, smaller sections detailing discrimination against indigenous people, people with disabilities, and corruption in government also are being cut out, according to the documents, end quote. Link in the show notes for citations in your asylum cases. Seems like quite the way to attack the reliability of these Department of State reports in your asylum cases, particularly if your claim is based on one of these groups being mentioned, and particularly if an immigration judge or ICE is arguing that the absence of mention of such issues indicates that everything is A-OK in the home country. Given how heavily immigration judges rely on the Department of State to deny, I'm not sure that this is giving the purpose that Secretary of State Rubio intended. The cite and note the argument. Also this week, the 11th Circuit joined a unanimous list of circuits holding that Indian nationals can't sue to get green cards based on the EB retrogression that occurred in late 2020. The case here from the 11th Circuit is Kanapuram et al. V. USCIS et al. And also this week, late Friday night, a memorandum was shared with me that essentially directs the Attorney General to attack lawyers who sue the federal government in federal court and their law firms. We are living in the worst of times. Can you imagine the prior administration doing a fraction of what is happening right now to those that it disagrees with? It is truly impossible to imagine. We seem to be in the midst of a blitzkrieg of terribles intended to confuse and to make legal opposition futile. We did not become lawyers to be scared by memorandum and sanction threats. At least I didn't. And I don't make frivolous arguments. The battle for the soul of America is here. It cannot be lost. And here are your 5 cases. Our first case is a matter of CARR, published by the BIA in 2025. This case is about incomplete asylum applications, issued by 3 of the appellate IJs who, it would seem, survived the most recent purges. And it pertains to an issue that I've oft had occasion to discuss on the podcast, and which many immigration attorneys have then emailed me about. Do asylum seekers really need to include detailed asylum declarations in their Form I-589 applications, cross-examination on a plate for DHS, and particularly where, as always, the non-citizen will be testifying in court in support of their claim. Interesting issue. The respondent here is from El Salvador and appeared without an attorney before an immigration judge for at least 3 hearings that spanned 8 years. The pro se non-citizen tried to file his Form I-589 asylum each time at those 3 hearings, but each time missed answers to certain questions. It's not an easy application. Finally, at the 4th hearing in 2024, the IJ instructed the respondent to file an updated asylum application in 13 days' time. This time, the non-citizen had an attorney, and he pulled it off. Huzzah! The immigration judge also said that the respondent needed to also file a declaration in support of his application, or the application would be deemed waived and abandoned. The respondent had a month and a half to submit that declaration. On the declaration, the respondent submitted it in English only, without the original Spanish that it had been translated from. 12 days after that, he submitted an updated declaration, also in English only. The IJ rejected it, and then denied the asylum application as abandoned. To the IJ, the new I-589, quote, contained more information than his previous submissions, but still lacked sufficient details, end quote. Meaning that without the declaration to fill in those perceived gaps, the I-589 was, quote, excluded, end quote, from the record, and so deemed abandoned. After that, with asylum gone, the respondent testified in support of an application for non-LPR cancellation of removal, which was denied in part because the respondent, quote, admitted to selling cocaine in 2023, end quote, in court. Not literally selling in court to the IJ and the trial attorney, but to past occurrences of cocaine sale somewhere else. Grammar can be fun. Anyway, with it all denied, it went to the BIA. And asylum is what we have before us in this decision. And on that, the BIA did not agree with the immigration judge. IJs have, quote, the authority to set and enforce filing deadlines, end quote. A quote worth remembering, litigators, hasn't been said by the BIA perhaps in 15 years. And when a non-citizen or any party fails to comply with a deadline of any kind, including a filing deadline, there can be consequences. And, quote, even where a Form I-589 is submitted to the immigration judge within the time permitted, the IJ is not required to consider it on the merits if it is incomplete, end quote. The BIA is relying on the regulations for all of this stuff. End quote, incomplete applications may be considered waived or abandoned, particularly where an opportunity to cure has been offered, end quote. That latter clause seems particularly important to me. Now, both the regulations and the form instructions, which I believe are treated like the regulations, state that I-589s that don't include a response to each question, that is unsigned, or that is unaccompanied by the required regulatory materials is incomplete, and so it could be deemed waived. Not only that, those I-589 questions, quote, require a specific responsive answer, end quote. A substantive answer, the BIA explains. In that way, states the BIA, immigration adjudicators can, quote, address a greater volume of applications and concentrate efforts on approving meritorious claims, end quote. Remind ICE, y'all! Seriously. Your client's awesome 4 I-589 answers have a BIA-sanctioned purpose that ICE could get behind, too. Alright, so there's all the law. In this case, the respondent's final Form I-589, the 4th one, met these requirements. As such, quote, the IJ erred in deeming the entire asylum application abandoned solely because the respondent did not submit a supporting declaration in the proper manner, end quote. And that's because a declaration is not a required part of an asylum application, nor is it one of the regulatory materials listed as being required. In fact, the fact that there is a regulation and regulation-like instructions that require certain other materials, and that those regulations and instructions don't require a declaration, is quite telling, explains the BIA. Flat out, quote, because declarations are not a constituent part of an asylum application, an IJ may not deem it abandoned solely because the respondent did not submit one, end quote. That's a big deal. But on the other hand, explains the BIA, it doesn't mean that IJs can't require submission of a declaration, or that an applicant can disregard an order. But then again, the remedy is pretty limited. Quote, if a supplemental document is not timely filed, the opportunity to file it is waived, end quote. So if you believe it's in your client's best interest not to file a declaration, the remedy that the BIA is stating isn't really that bad. It's kind of what you want. Exclusion of the opportunity to file a declaration. It just puts you in the fairly improper position of ignoring a court order and risks upsetting the judge. Not great, but our duties are to our clients, and the BIA has sanctioned it in practice. Definitely puts us in a minor ethical quandary, though. And yeah, your client better testify quite well if you're considering this strategy. So, remand. As to cancellation of removal, the court affirmed the IJ's denial because of the cocaine admission. Per se good moral character bar within the statutory period. Even without a conviction. That's I&A section 101F3. But what if cocaine's not cocaine? It looks like we're in New York here after all. Peak US v. Charas, episode 189, and US v. Minter, episode 176. Peak, I say! Unpeaked here. And again, it was a remand for Mr. CARR to pursue his asylum claim again. Word up. And congratulations, Karine Brown, for the respondent. And I'm not done! Good on the BIA for a reasoned, text-based decision in an otherwise somewhat lawless time. I still don't understand, however, why IJs should be permitted to require declarations at all. If you refuse an IJ's order to submit one and are adversely impacted, or if you comply and DHS wrecks your otherwise truthful client's testimony, you might have an argument that the declaration requirement made removal proceedings fundamentally unfair. Don't get me wrong, that's now an argument to make in front of the circuit that you should still exhaust before the IJ and the BIA. Not submitting a declaration when ordered might really upset an IJ, but doing so gives DHS a guidepost to cross-examination and a documentary basis to nitpick every little date, name, and other possible discrepancy an asylum seeker may make inadvertently when testifying to those exact same issues months or years later in immigration court on the stand. Where else must a lead litigant submit their testimony before testifying to get a benefit in a court? Experts, yes, but parties to a litigation? Requiring an asylum declaration seems like a non-frivolous, fundamental fairness argument to me. And that is matter of CARR. Next is matter of Door, published by the BIA. This case is about controlled substance offenses. It's also kind of a big deal, and it's a remand from Door v. Garland, from the First Circuit, episode 121. And I'll bet anyone it's gone back up to the First Circuit. Mr. Door is from Haiti and is a lawful permanent resident. In August 2018, though, he was convicted of possessing marijuana with the intent to manufacture, distribute, dispense, or cultivate in violation of Section 32CA of Chapter 94C of the Massachusetts General Laws. For that, DHS charged him as removable under I&A Section 237A2BI, a non-citizen removable for having been convicted of a violation of a law relating to a controlled substance. I wonder why DHS didn't also bring an aggravated felony drug trafficking allegation. Might it be that DHS fears that Massachusetts' statute covers more conduct than generic trafficking? I don't know. Might that have been what the First Circuit's Door decision was about? I can't recall, but I don't think so. Anyway, it all went back on remand from the First Circuit to the BIA and way back to the IJ, where Mr. Door moved to terminate his proceedings, arguing that his 2018 conviction can't make him removable because Massachusetts' definition of marijuana in 2018 was broader than the federal generic definition of marijuana today at the time of the removal proceedings. That's how I've always understood the categorical approach to generally work. And it's very important here because the federal definition of marijuana arguably became overbroad vis-a-vis many states' definitions of marijuana, including Massachusetts, in December 2018, when federal law was amended to exclude all hemp from the marijuana definition. Massachusetts, you see, only excludes, quote, industrial hemp, end quote, but not other kinds of hemp from its marijuana definition. The IJ held that my understanding of the categorical approach is wrong. For drug offenses, you compare the state drug schedule at the time of conviction to the federal drug schedule at the time of conviction. And on this, the BIA affirmed. I guess I've always been wrong, at least on drugs. To the BIA, this has been the law in the 9th, 11th, 3rd, and 2nd Circuit for quite a few years. Quote, the time of conviction is the relevant point for determining whether a respondent's state conviction is for a controlled substance offense, not the time the respondent's removability is adjudicated in immigration proceedings. End quote. This also, of course, follows from Brown v. United States, the Supreme Court's decision from episode 213, where I, of course, discussed this possible eventuality. As in that case, the Supreme Court said something similar to this in the ACCA context. The BIA notes this too. By the way, as I said back then, I could be reading Brown v. United States wrong, but I'm pretty sure Justice Alito and the majority said that Florida cocaine is overbroad vis-a-vis the federal controlled substance list in Brown. Of note, again. In what appears designed to undermine the categorical approach entirely for drug offenses, the BIA explains that Congress amends the drug schedules with criminal law in mind. Quote, these criminal laws of general applicability are not primarily about immigration, and thus whether offenses involving that substance result in removal is secondary. End quote. The BIA makes these holdings despite the BIA kind of recognizing that the Supreme Court assumed in Mullooly and Moncrief that the time of the drug comparison was the time of removal proceedings. But that issue was not directly before the Supreme Court in those cases, explains the BIA. Doing the comparison of both schedules at the time of conviction, explains the BIA, actually gives non-citizens a benefit of what might make them removable down the road. But it seems like the Federal Controlled Substance Act is constantly playing catch-up to the states. So tethering the analysis to the schedule at the time of conviction may very well benefit some non-citizens, even if it is more difficult to conduct. And yes, indeed, then, criminal counsel can obtain an immigration analysis pre-plea explaining whether overbreadth exists, and that analysis should be good for the future under this BIA decision. Rejecting some other arguments and believing this the best reading of the statute, the BIA affirmed denial of the motion to terminate. See you in a year or two, First Circuit. Two things. First, is not the BIA implicitly recognizing that post-December 2018 marijuana offenses in Massachusetts are broader than the federal definition? Sure seems like it to me. And two, the bigger holding. If this holding is as broad as the BIA seems to intend it, I truly don't understand how this will work in practice. Drug schedules are one thing, but tethering removability to the federal definition of the generic offense at the time of conviction rather at the time of removability for all things doesn't make any sense to me, especially if it's applied to case law developments as well. Is that what the BIA is saying here? Kind of seems like it. Quote, the reasoning for the approach we adopt here applies not only in the controlled substance context, but also as to criminal convictions more generally. End quote. Quite the vague sentence to make, especially without further explanation or citation. And how can that be true? If, for example, a state crime was a crime of violence under existing law in, say, 2017, but it's clearly not post-Bondi because the statute indivisibly permits a conviction with a reckless mens rea. And if removal proceedings are occurring today, there's no way an IJ can find the conviction an aggravated felony. Right? Or, sticking with crimes of violence, what about 18 U.S.C. Section 16A in DiMaia? If, say, a 2014 conviction that matches a Section 16A crime of violence is today in immigration court, it can't be a crime of violence now, because the Supreme Court later found Section 16A unconstitutional in DiMaia. Right? I talked this out over email with some of the smartest people I know, and they seem to think that there might be a distinction between case law changes explaining what the INA always meant and factual changes to the generic definition, such as the Controlled Substance Act schedule changes. I'm not sure how much I buy the distinction, but if that is a distinction, then maybe the CSA changes are the only thing that this case applies to. But if so, why the vague sentence, BIA? I don't know. Bet you we're going to find out. And that is Matter of Door. Moving on to Duarte de Martinez v. Bondi, published by the First Circuit on March 19, 2025. This case is about hardship. Ms. Duarte is from El Salvador, has been in the United States for a long time, and so applied for non-LPR cancellation of removal when placed in removal proceedings. That, of course, requires also that she establish exceptional and extremely unusual hardship to a qualifying relative, which she has, 9 and 10-year-old U.S. citizen sons. They're known as AM and JM, respectively, in this case. As it turns out, AM has an intellectual disability and only speaks English. The evidence here showed that the only school that offers special ed classes that are needed for AM in El Salvador teaches only in Spanish. And his disability makes it extremely difficult for him to learn a new language. Lots of testimony and evidence supported this and more about his learning disability and needs. Indeed, he's currently in 5th grade but performing at a 1st grade level. He has speech problems. And again, it seems like it's agreed that Ms. Duarte, if removed, will bring her children with her to El Salvador. The IG did not believe that all of this equated to exceptional and extremely unusual hardship, and the BIA affirmed. After all, reasoned the agency, there are private schools in El Salvador. Plus, quote, to the extent that those services may be inferior to AM's current services, evidence that a qualifying relative will experience a lower standard of living in the country of removal, including a lower standard of medical care, is insufficient in itself to support a finding of exceptional and extremely unusual hardship, end quote. That's a matter of JJG from 2020, which was quite rough, if I recall. Also reasoned the BIA here, quote, unfortunately, a language barrier is a common hardship resulting from a respondent's removal, end quote. Stating that it weighed everything cumulatively, the BIA affirmed denial. The First Circuit remanded. True, some of the arguments Ms. Duarte was making are factual challenges to the degree and nature of hardship, something that the Patel decision prevents review of. But Ms. Duarte also argued that the agency failed to follow its own precedent in making its hardship finding, and that is a question of law. Because, reasoned Ms. Duarte, the agency failed to make a, quote, individualized inquiry, end quote, into AM's specific circumstances. That requirement, the individualized inquiry, is mainly from the 2002 decision, matter of Gonzalez-Salinas, and it has to be a cumulative analysis. That's matter of JJG again. Gotta be quite the particularized analysis, that is, the cumulative hardship analysis for the qualifying relative. Here, in contrast, explains the First Circuit, the agency appears to have believed the language barrier stuff insufficient, but didn't recognize the impact that a language barrier problem would have on a child who already has significant intellectual and learning disabilities. Maybe a language barrier is, quote, common, end quote, as the agency believed. But for AM, how could that be? Heck, quote, even an ordinary language barrier may be relevant to the cumulative hardship analysis, end quote. But here, if it will practically prevent AM from furthering his education at all because of his other problems, very well might meet the sufficient hardship standard, and at a minimum, the agency must apply its precedent to AM's circumstances specifically. After all, the agency precedent that the BIA relied on in this very decision makes clear that depriving a U.S. citizen child of, quote, all schooling or an opportunity to obtain any education, end quote, will meet the hardship standard. The allegation here is that because of his disabilities, AM, quote, can never learn Spanish, end quote. The private school stuff doesn't make much sense to the First Circuit, where again, the argument is that AM can never learn Spanish. Perhaps most importantly, it believes the BIA in particular was comparing AM's case to cases where the child is otherwise doing all right, but for the language barrier or some other common learning hardship. You can't do that. AM is special. All qualifying relatives are special and must have their specific aggregate facts analyzed under case law. To the court, the BIA seems to have been citing various precedent to reject AM's hardships without ever really looking at the full picture of who AM is and the effect going to El Salvador will have on him, specifically. It very well may be that in El Salvador, AM's disability will effectively prevent him from obtaining an education. The agency needs to tangle with that. Even if it and other circuits regularly deny learning disability hardship cases, those cases aren't AM's case. Tangle with the facts! The court demands it. Meaning, congratulations Randy Olin for petitioner. Seems like he got pretty close to getting the First Circuit to simply outright reverse the hardship finding and grant non-LPR cancellation, too. Almost. Getting a remand. And that is Duarte v. Martinez v. Bondi. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025, that's IMMREVIEW2025. Keep up and join the good fight. All losses for the non-citizen from here on out, but stay with me! Continuing on with Salinas v. Bondi, published by the 8th Circuit on March 19th, 2025. This case is also about controlled substance offenses, and it involves a very similar, dare I say identical issue to Matter of Door that we just did. This case was published the day after Door. Ms. Salinas is from Mexico and became a lawful permanent resident in 2007. But 4 years later, she was convicted in North Dakota for marijuana possession with the intent to deliver. And then in 2021, again in North Dakota, 2 counts of aggravated assault of a victim under 12 years of age, for which she received a sentence of 10 years imprisonment, with 1 year of that sentence suspended. Ms. Salinas conceded removability for the second thing and sought LPR cancellation of removal. Despite being found removable, the IJ conducted a full removability analysis for the controlled substance thing, finding that the North Dakota crime was a Section 237A2BI violation of a law relating to a controlled substance. The IJ rejected Ms. Salinas' argument, the same one in Door. Ms. Salinas argued that at the time of her conviction, North Dakota criminalized possession of hemp in its marijuana definition, but at the time of removal proceedings, federal law did not. The December 2018 federal amendment. The IJ held here that you compare the state and federal drug schedules at the time of conviction, not at the time of removal proceedings for the federal CSA. Okay, fair enough, but Ms. Salinas also argued that even then, North Dakota's definition is not a match to the federal definition because North Dakota criminalizes more parts of the marijuana plant than does the federal government. An argument that the 8th Circuit completely sustained in Gonzalez v. Wilkinson, episode 46, as regards Florida's marijuana definition. The IJ didn't buy it and sustained the drug removability charge. The IJ also denied LPR cancellation of removal because a Section 237A2 conviction stops the clock for continuous residence required of any cancellation of removal application, and with the clock stopped in 2011, Ms. Salinas didn't have her 7 years as an LPR as the relief requires. BIA affirmed. As did the 8th Circuit. This conviction is North Dakota Code Section 19-03.1-231. I don't get many North Dakota crimes on the pod. And all parties here agree that the statute is divisible vis-a-vis the drug, and that here, the drug at issue is North Dakota marijuana. Again then, the dispute is what version of federal marijuana do we compare North Dakota's definition of marijuana to? Which of course implicates the hemp argument, but then second, even without the hemp argument, is North Dakota marijuana a match? On the first issue, the 8th Circuit essentially said the same things to what the BIA just said in Door. The 8th Circuit additionally relied on all that out-of-circuit precedent. And I'm not going to rehash all that right now, pun intended. Of note, though, the 8th Circuit adds that, quote, the CSA schedule is a moving target. Since 1970, approximately 160 substances have been added, removed, or transferred from one schedule to another, end quote. And of course, explains the 8th Circuit, there's the Brown decision from the Supreme Court last term. So, add the 8th Circuit to apparently this universal list. Only in the Section 237A2 BI context for now, though. Although I'm pretty sure this rationale will likely apply to all the drug inadmissibility or removability provisions. You apply the state drug schedule at the time of conviction to the federal CSA at the time of conviction. And fair enough. But what about the comparison of North Dakota marijuana with federal marijuana? The 8th Circuit didn't agree with the argument. It did not even cite Gonzalez. At the time of conviction in 2011, North Dakota's definition, in pertinent part, criminalized possession of, quote, all parts of the plant cannabis, end quote, including certain seeds and other stuff, but excluding the mature stalks and other stuff. The federal government, in turn, has almost the exact same definition, exclusions and all, but it criminalizes, quote, all parts of the plant cannabis, sativa, L, end quote. So, I mean, that's definitely a textual difference, right? North Dakota is criminalizing all parts of the plant cannabis, and the federal government is criminalizing all parts of the plant cannabis, sativa, L. But it's not material, said the 8th Circuit. In fact, it said it way back in 2006, likely in an ACCA case. There, the 8th Circuit held that, quote, Congress clearly defined marijuana as cannabis sativa L in the CSA. We are persuaded that Congress adopted cannabis sativa L, believing it to be the term that scientists use to embrace all marijuana-producing cannabis. The other named sorts were not seen as separate cannabis species, end quote. I don't know, though. Are there separate marijuana species? And are some excluded from federal prosecution? Interesting issue for another circuit that hasn't apparently directly ruled on the dispute. But rejected it was here. And that is Salinas v. Bondi. Our final case this week is Singh v. Bondi, published by the 9th Circuit on March 17th, 2025. This case is authored by 2 9th Circuit judges and 1 District Court judge, sitting by designation, who end up concurring with themselves to essentially urge the 9th Circuit to go en banc and vacate Singh v. Garland, episode 232. Let us begin. It's all really about a matter of RKK. Mr. Singh is a Sikh from India who brought a man party type asylum claim. He claims to fear the governing BJP party due to threats and attacks that he suffered. He was found not credible by the immigration judge and the BIA, and the Ninth Circuit very much agrees with that finding. So the facts are conveyed by the court in a certain manner here. And I will admit, as told by the Ninth Circuit at the semi-surface level, the story of harm conveyed is pretty similar to many other Sikh-based asylum claims of late discussed on the podcast. As always, that could mean that the non-citizen is lying, or it could mean very similar things are happening to similar people in India because persecutors have the same motivations and tactics. As relevant here, DHS presented an exhibit on cross-examination that contained 6 redacted declarations from other asylum applicants, quote, that were strikingly similar factually and in places linguistically to Mr. Singh's declaration. The DHS exhibit pointed to no fewer than 9 parallels in the narrative structure between each of the other declarations and Mr. Singh's declaration, end quote. DHS did the same thing on episode 232 in that Singh v. Garland decision, and I wouldn't be surprised if it was the very same or a very similar chart. The similarities identified were, quote, 1, 2 confrontations involving 2 opposing party members, 3 driving vehicles with BJP logos on them, 4 an attack by 4 individuals, 5 involving sticks, 6 a rescue by strangers, 7 that are usually farmers, 8 the refusal of police to take a report, and 9 the threat of arrest, end quote. And to be honest, I'll just add the involvement of a father as well. Seems to almost always be happening. The DHS exhibit identified other things too. Given this, the IJ gave Mr. Singh time to review the materials and set another hearing. Quote, at that follow-up hearing, counsel for Mr. Singh argued that the similarities existed because they reflect how the BJP and the police generally operate in India, end quote. The IJ was not moved, found Mr. Singh not credible, and denied. The IJ also made a frivolous asylum finding which bars Mr. Singh from all I&A relief forever. The BIA affirmed. As I mentioned, the Ninth Circuit affirmed too, and then concurred with itself. Of note, while an adverse credibility finding is reviewed deferentially, quote, a determination that an applicant knowingly made a frivolous application for asylum is reviewed de novo for compliance with the procedural framework outlined by the BIA, end quote. Still all affirmed, though. This despite Singh v. Garland, episode 232. Not the many other Singh v. Garlands and Singh v. Bars that we've discussed on the podcast. Matter of RKK, quote, permits immigration judges to consider strikingly similar affidavits submitted by asylum applicants in unrelated proceedings as a basis for an adverse credibility determination, end quote. But in Singh v. Garland, the Ninth Circuit held, among other things, that matter of RKK is more about grammatical and language similarities, and similarities in narrative structure. It shouldn't be used to make an adverse credibility finding based on, quote, broad factual similarities, end quote, between declarations. Unmentioned by the Ninth Circuit here, the Singh v. Garland panel also had some language that strongly, to me at least, seemed to support an argument that a due process violation occurs when DHS relies on redacted affidavits because it then prevents the non-citizen asylum seeker from investigating and defending against those stories, if I recall. Anyway, the Ninth Circuit panel here noted that indeed, there were multiple grammatical, language, and narrative structure similarities between affidavits, and that in any event, Singh v. Garland should be read to mean that it is error to, quote, focus exclusively on broad factual similarities between the declarations, end quote. Not that IJs can't at all consider that things are factually similar, in addition to the grammatical, narrative, and textual similarities, the word exclusively being emphasized by the court here. Indeed, Mr. Singh's declaration contains multiple copy and pasted sentences identical to those in the declaration of another applicant represented by Mr. Singh's attorney, end quote. Not going to go into all the similarities, but the panel sees a lot, suffice it to say. Also, for example, the affidavits contain similar extraneous details that seem unnecessary to a past persecution claim. Having so held, the Ninth Circuit continued on that the IJ properly implemented the procedural safeguards ordered by both matter of RKK and to make a frivolous asylum finding. Essentially, you gotta give meaningful notice of the similarities, a reasonable opportunity to explain, and then consider everything in totality, under matter of RKK. Done sufficiently here. Similar requirements for a frivolous finding, but not identical. and sufficiently done and supported in this case, said the panel. Cat protection denied too. So in summary, review the Singhs when making your Sikh-based asylum claim in the Ninth Circuit. There's a thin line to walk here because, well, Ninth Circuit judges very much disagree with one another. But this Singh decision, the Bondi version, was quite careful to cabin its analysis within that performed in the other Singh of the Garland variety, episode 232. So really, that's the one that governs when push comes to shove. As I mentioned, the panel concurred with itself to make clear its true belief that while it of course needs to follow the prior precedent rule, it believes that Singh v. Garland, episode 232, was wrongly decided. And look, I'm certainly not condoning fraud in immigration court. I will, however, reread the due process thing from Singh v. Garland. So as I discussed, no mention as I could see of the due process stuff from Singh v. Garland in this decision here, but it seems important to me. From Singh v. Garland, quote, "The agency's reliance on the redacted declarations did not afford Mr. Singh a meaningful opportunity to offer reasonable explanation or credible evidence to dispel doubts about the authenticity or reliability of the initial evidence," end quote. To me, that doesn't really have anything to do with similar wording, narrative, structure, or anything like that. Seems to me that DHS's reliance on redacted affidavits will per se violate matter of RKK's mandate to give the non-citizen a meaningful opportunity to explain. That seems to me what Singh v. Garland was saying. I'd keep arguing it. Why not, if your client's telling the truth? And that is Singh v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.